Runkle of the Bailey's court battle came to an unceremonious end a couple of weeks ago when the Supreme Court declined to hear his case. But not all is lost, as this could secretly be a huge win for gun owners in Canada. Let's have a look. Welcome back to the channel. So today we are going to be continuing our CCFR versus Canada series. We're not actually going to be starting off that way though, because we have another case to discuss first. And I have some unfortunate news on that front. Runkle's application for leave to appeal to the Supreme Court was dismissed last week on October 9th. This means that he applied to the Supreme Court and they simply didn't want to hear his case. Now, we don't know the specifics of why the application was denied, as the Supreme Court doesn't make that information public, but it's also not entirely that weird. Like, the Supreme Court usually hears less than 10% of their applications in any given year as it is. So, why are we talking about Runkle's case anyway, and how does it relate to the CCFR's ongoing battle? Well, I don't want to get into it too much, as I expect he'll also want to talk about it at some point, and this is certainly his story to tell, but here's a quick rundown of what happened so that you can understand why it's important to the CCFR's case. So if you all remember a couple of years back when the first 2020 Order in Council prohibited over 1,500 models of these so-called assault-style firearms, the registrar also sent out letters telling owners that their registration certificates of these firearms had also been nullified. A number of different cases popped up disputing these nullification orders, and the most notable of which is the case of Canada versus Smykot. And in Smykot, even though it was acknowledged that there is no basis for nullification either under the Criminal Code, the Firearms Act, or the Order in Council, these registration certificates were still somehow nullified because reasons. After all, this is the Canadian court where everything is made up and the laws don't matter. However, the applicants argued that the RCMP, in this case the registrar, that the registrar was involved in this decision, and therefore these nullification orders are no different than a revocation of a registration certificate, which means they should be challengeable under Section 74 of the Firearms Act. However, Smykot found that, much like in the CCFR's case, the registrar was not involved in the decision-making, and that it was the change in the law itself which nullified these registration certificates rather than the registrar revoking them. In Runkle's case, they challenged Smykot's ruling in a couple of different areas, the most important of which was that they disputed the idea that the registrar wasn't making decisions regarding the classification of firearms, specifically when it came to unnamed variants. Like, it's fair to say that the firearms which were declared by name in the 2020 Order in Council were prohibited by the Governor and Council and not by the registrar. Like, you could maybe argue that the RCMP was involved behind the scenes, and surely they were, but ultimately and legally speaking, the decision was formalized and made into law by the regulation and by the Governor and Council, not by the RCMP. However, Runkle's case disputes that this is not the exact same thing with an unnamed variant. Because when it comes to the classification of an unnamed variant, someone other than the Governor and Council is making that determination, which in this case has to be the registrar. Being that there is no definition or common understanding of what a variant is or isn't, that is an interpretation and a decision which must have been made by the registrar. Now, of course, the Supreme Court shot this down, basically saying that unnamed variants are no different than named variants, which caused Runkle and Swanson to appeal to the Supreme Court, but the Supreme Court refused to hear their case. So now, that ruling has been carved in stone, so to speak. But this also creates a problem. What this means, like fundamentally, is that Runkle's case says that we are unable to legally challenge the registrar's interpretation of the word variant, which means that the registrar's interpretation of the word variant is essentially indisputable except during a criminal trial, and most importantly, that the Supreme Court is okay with that. So how does all of this relate to the CCFR's court case? Well, if you remember from previous episodes in the series, the courts have ruled that the Firearms Reference Table, the FRT, is not legally binding because the Specialized Firearms Support Service, which is a branch of the RCMP, is not actually making classification determinations. Chief Justice Montagny at the Federal Court of Appeal said that there are no decisions being made and that they are merely engaging in fact-finding. He cited the case of Act and Transport for this ruling, but it's very similar to what was said in Runkle's case. However, there was one very important and earth-shattering distinction between these two cases. Unlike in Runkle's case, where the court ruled that you can't even challenge these decisions because a decision isn't even being made and therefore there's really nothing to review, in the CCFR's case, Chief Justice Montagny ruled the exact opposite thing, and he said this in paragraph 76 of his ruling. More importantly, any decision having legally binding effect on an individual, whether supported by the FRT or not, can be judicially reviewed. For example, any nullification letters sent by the registrar to firearm owners involving unnamed variants are subject to judicial review, and the decision of the registrar would be reviewable on the reasonableness standard. And that was the exact opposite thing which was ruled in Runkle's case. And the Supreme Court just solidified the outcome in Runkle's case, meaning that the CCFR's case has a legal error in it. And it's not a small one either. So the odds of the CCFR heading to the Supreme Court may just have gone way up as a result of Runkle's loss. Now, the reason I say that this isn't a small mistake is important, because a small mistake simply wouldn't be enough to catch the Supreme Court's eye. So instead, this is an error which is actually pretty central to the case, because now this means you have no legal way of challenging the classification of an unnamed variant until after you've been charged with the crime of having said variant under either Section 91 or 92 of the Criminal Code. The definitely totally not legally binding opinion of the Specialized Firearms Support Services and the Firearms Reference Table suddenly becomes a pretty severe problem for businesses and individuals who must adhere to it. Because for those of you who might have watched the case live, you might even remember this, but when this question came up, Justice Stratus laughed out loud at the ridiculousness of this idea. On day 2 of the review, Justice Stratus asked the government lawyers what would happen if a business ignored the Firearms Reference Table and simply continued manufacturing and selling one of these unnamed variants as though it had its previous classification status. The government's lawyers informed the court that of course they would be arrested and charged under the Criminal Code, but that it's okay because they can still decide the outcome later in court. Justice Stratus quite literally had himself a good chuckle at how ridiculous of a suggestion that was. Yet when it came time to rule, he appears to have gone against his better judgment for some reason. Now, it would be easy enough to chalk this up to some kind of contempt or corruption as we're so used to experiencing as lawful gun owners, but we shouldn't toss around such allegations so callously, as there could very easily be another explanation in this instance. And that reason was likely the very idea that these classification determinations can be challenged before such criminal charges arise. Now, myself personally, I don't think that that's any excuse, but the courts tend to be quite jaded about this kind of thing. Like, from their perspective, having to take tens of thousands of dollars, if not more, and years of your life fighting this question out in court, that's just the way the world's supposed to work. And they don't need to answer these questions ahead of time for us because in their mind, that's a reasonable alternative. But seeing as the Supreme Court has denied Runkle's application, the judicial review door is now closed to them. Because now you cannot challenge the classification of an unnamed variant in court prior to a criminal trial, which means Chief Justice Montagny is wrong in paragraph 76 of his ruling where he says otherwise. This means that since the Firearms Reference Table is unchallengeable outside of a criminal trial, it is, for all practical effects and purposes, a de facto legal document which can and will and does lead directly to criminal charges against individuals, which is exactly what the CCFR alleges in their case. This causes the baseline rationale for the ruling of the unlawful subdelegation of authority to fall apart, even though it was already on shaky grounds to begin with. The Firearms Reference Table becomes an opinion that we cannot question or debate until we've been charged with a crime and our freedom is on the line, which means we can't know the answer to the question of whether our firearms are prohibited variants until after the judge swings his or her gavel and determines us to be guilty of the crime or not. And this is also a problem for the vagueness of the word variant, which is a constitutional issue, as the unlawful subdelegation of authority has always been. Because the courts appear to be very happy with the idea that the Firearms Reference Table is both simultaneously not legally binding, and yet somehow is legally binding. Like it's Schrödinger's Firearms Reference Table. But the Supreme Court precedent for the threshold of vagueness is this. The impunged provision must afford citizens fair notice of the consequences of their conduct and limit the discretion of those charged with its enforcement. Yet an unchallengeable Firearms Reference Table, by its very nature, is an entirely discretionary enforcement of the law. It is a 100% discretionary call being made by the RCMP. We saw this with the prohibitions of firearms like the Crypto or the Sterling Arms R9. No sane use of the word variant should have led those firearms to becoming prohibited variants of the AR-15 or the AR-180B. Yet when you have the example of the Crypto specifically, the Crypto was designed from the ground up with the intention of being compliant with the C21's evergreen definition of what an assault-style firearm is. Yet despite that, during the technical briefing for the confiscation program, it was said that the Crypto will not be available for compensation as owners should have known that it was always an unnamed prohibited variant even before they bought it.
The Crusader Arms Crypto. So you have to destroy the Crypto, hand it in for destruction, with no compensation. And I asked about that, and they said the Crypto was always was prohibited, and people never should have bought it. That is the because it was a variant of an AR-15.
But very clearly, very evidently, they had no such idea, meaning that citizens were not afforded fair notice. But not only were citizens not afforded fair notice, but the RCMP was also all too happy to issue reference numbers for these transfers, and Crusader Arms was manufacturing these firearms for distribution. None of these parties were aware that the crypto was supposedly always a prohibited unnamed variant of the AR-15. Because if it's true that it always was a prohibited firearm, and if it was actually obvious that it always had been a prohibited firearm, then Crusader Arms and retailers should have been charged with a crime for making it, and so should anyone else who bought one, and you could probably even get the RCMP in on that for entrapment as well, for approving these transfers through their firearms reference number system. And so, if the firearms reference table or the registrar is not legally challengeable on the question of unnamed variants, as Runkle's ruling has decided, that exemplifies the exact standard of what vagueness is in the law, and it makes enforcement of the word variant a purely discretionary call by law enforcement, which is exactly what the Eichenberg applicants said during the CCFR's court case. Without the firearms reference table, there would be no way to understand what a variant is. But with an unchallengeable firearms reference table, the only way to dispute that opinion is to incur criminal liability. One little side note, in paragraph 70 and 71 of his ruling, Chief Justice Montani dismissed these concerns that without the firearms reference table, there would be no uniformity in the interpretation of unnamed variants among manufacturers, the industry, individual owners, or law enforcement officers. Yet then, just, a few lines later in paragraph 73, he openly agrees that the only effect of the absence of the firearms reference table would be to make the application and enforcement of the regulations more complicated and less predictable. Talk about your cognitive dissonance. But again, this serves to prove that even in his own words, the word variant is vague. According to him, the only thing that the firearms reference table does is make the application and enforcement of the regulations more predictable, meaning that without the firearms reference table, the word variant would lead to extreme discretion and variance in enforcing the law, which is not permissible. That is the very thing that vagueness is supposed to stop. And paragraph 73 of the Crown versus Levkovic says that expert evidence alone cannot serve to define the elements of an offense. Otherwise, it would be considered vague. Now, this isn't to say that expertise is irrelevant or anything, but it can't be the sole basis for the boundaries of the law, which Chief Justice Montani clearly believes to be true in the CCFR's case. Because in his own decision, he explains that without the existence and the expertise of the firearms reference table, the use of the word variant would be essentially unworkable. If you want to learn more about, the variance and vagueness and subdelegation of authority and the CCFR's court case and everything else, please check out the previous videos in this series. The purpose of this video was not necessarily to get back into all of that again. The purpose was to highlight how a small legal loss might still turn into a huge victory for us gun owners down the road. Weird as it sounds, every time we lose, we sort of get closer to winning. At least, that is, if it's even possible for gun owners to win in court at all anyway. Because there's certainly enough pessimism out there regarding the court's treatment of gun owners, and a lot of it is not unfounded. I mean, heck, a lot of it is visibly present in the CCFR's case. But it might also be that the federal court and the Federal Court of Appeal haven't really made any legal mistakes, and it's the precedents themselves which bear the responsibilities for these contradictions. So who knows, if they get to the Supreme Court, maybe the Supreme Court can see the mess that their precedents are causing in the lower courts, and they can set this right. Not that I think most of our issues are a problem of precedent, but some definitely are, particularly regarding Section 15 of the Charter and the Bill of Rights. So if the Supreme Court will hear the CCFR's case, who knows how this might shake out? And since the Supreme Court won't hear Runkle's case, then it stands to reason that they'll need to hear the CCFR's case in order to fix the contradiction that the lower courts have now created. As far as when we might hear back about that decision, it's likely going to be sooner rather than later, although it's tough to say for sure, but probably in the next couple of months or so. Runkle's application took just under 6 months to decline, and if we follow a similar timeline, which doesn't seem unreasonable, that puts us right around Christmas for the CCFR's case. If their application is accepted, a court date will be set for some time after that, so who knows? With any luck, we might have something big to celebrate come the new year. All that being said, I'd like to thank you all for watching, and we'll see you in the next video.